Do you know the difference between an unsecured and a secured debt? Do you know how these different kinds of debts might be treated in bankruptcy? Today, I want to break down the difference between unsecured and secured debts and why it matters if you might be filing for bankruptcy. Hi, I'm Michael Brower, a staff attorney here at the law offices of Lee M. Perlman, where we've been helping people get fresh financial starts for over 30 years. Remember, contacting a bankruptcy attorney does not mean that you're committed to filing bankruptcy. It means that you want to understand your options towards your own financial fresh start. If you find this video helpful, I want to remind you to like and subscribe to this channel and contact our office with your specific questions. To explain how secured and unsecured debts work and how they work in bankruptcy, we're going to start off by defining some basic terms. First, let's talk about the most fundamental, which is debt. A debt is a legal obligation that one person has to pay another person money. That other person, the one who's going to get the money in the situation, that person's called a creditor. Collateral is another specialized term you may have never heard before. A collateral is a piece of property, whether it has any value or not, that is used to back up a loan, to give a little bit of guarantee to the creditor that they're going to get paid. And the last specialized term that I'm going to talk about to set the table here is a lien. A lien is a legal interest that a creditor has in the collateral. It's their right to take it if they don't get paid under the underlying debt. Now that we've defined some terms, let's start by talking about unsecured debt, which is probably what most people think of when they think of debts. Let me start off by giving you a few examples. Credit cards, medical bills, personal loans are generally speaking unsecured debt, meaning there's no collateral involved. It's a legal obligation that you might have to pay back a loan you take. But there's other kinds of unsecured debts too. Debt might arise from a lawsuit. Maybe you're in a car accident and the other driver sued you for damage to their vehicle. Or maybe there's a personal injury claim. Somebody says you hurt them and they cause them damages. Those are other sources of potential unsecured debts. The way that you can tell a debt is unsecured is because there's no collateral involved. In a credit card, a personal loan, or even a car accident lawsuit situation, there's no property backing up the obligation that you have to pay the creditor. The creditor has to collect that money from you. But how can they do that? In New Jersey, there's a few common ways that a creditor can try to collect on an unsecured debt if it's not getting paid voluntarily. First, and the most obvious, is to send that debt to collections. That means phone calls and letters and text messages, sometimes to the point of harassment, to try to force somebody or make them uncomfortable enough that they'll pay the debt themselves. There's also credit reporting. Credit reporting means the creditor can report to the credit bureaus and make it public information that a debt has not been paid. This sometimes puts enough pressure on somebody to pay the debt. If the debt's still not paid, a creditor might resort to the courts and file a lawsuit. The point of a collections lawsuit is to get a judgment or a court order that says the creditor is owed the money. Once that creditor has a judgment in hand, they can do things like take money out of bank accounts, intercept wages that are earned, or otherwise try to collect the debt by force. This is usually the pain point where most people reach out to contact an attorney. Secured debt, on the other hand, is very similar to unsecured debt, except there's a piece of collateral involved. A car loan is the perfect example of a secured debt. In a car loan, you borrow money to purchase the vehicle from a bank or a lender, and the lender takes a lien in the collateral, in this case, the car. If you don't pay the car loan on time, the lender is allowed to take the car back from you by force, or more commonly known as repossess the vehicle. They can then take the vehicle to an auction to try to pay off the unpaid debts. One important difference for a secured creditor is that they may not have to go to court before they enforce the debt. In our example of a car loan, the lender does not have to go to court before they repossess the vehicle. Once you're late on your car payments, they're allowed to repossess the vehicle. Some secured creditors may have to go to court. The most common example here is a mortgage company, where your house is the collateral for a mortgage loan. If you're late in your mortgage payments, the mortgage company has to go to court first in foreclosure and get a judgment in foreclosure before they can take your property from you in a sheriff's sale. No matter what kind of secured debt we're talking about, if the creditor takes the collateral and sells it to pay off a portion of the debt, and there's any debt left unpaid, that remaining balance is called a deficiency. And that's an unsecured debt because the collateral has already been taken. There's no more collateral to secure the loan. Now we're left with just an unsecured debt. Now that we've laid out what a secured debt is and an unsecured debt is and how they differ from each other in terms of collateral, let's talk about how they work in bankruptcy. Generally speaking, unsecured debts are going to be dischargeable in bankruptcy, whether we're talking about Chapter 7 or Chapter 13. There are a few exceptions. Student loans, child support, alimony, and recent income taxes are generally non-dischargeable in Chapter 7 or Chapter 13 bankruptcy. Otherwise, credit cards, medical bills, any kind of personal loan, or even lawsuits usually can be discharged in bankruptcy. And since we're talking about dischargeability, what does a discharge get you? A discharge means that the creditor can never legally enforce the debt against you personally again. They can't sue you or write to you in collections or make negative credit reporting because you owed them money. That's the benefit of a discharge. A secured debt in bankruptcy is treated very similar to an unsecured debt, except the lien against the collateral is not automatically discharged. That means even though your car lender may not be able to sue you after you file Chapter 7 bankruptcy, they still have a lien on the vehicle. If you don't make your car payments, they still repossess the vehicle. They can't sue you for the difference, but you're without a car. It's important to know this distinction because there are some ways in Chapter 7 and Chapter 13 bankruptcy especially to deal with secure debts. These get complicated and go well beyond a short video. If you have a secured debt, or if you're not sure whether your debt is secured or unsecured, and you're considering filing for bankruptcy, it's important to talk with an experienced attorney right away. You need to understand your options and your rights so that you don't have any nasty surprises. Remember, contacting a bankruptcy attorney is not a commitment to file for bankruptcy. It means you want to understand you can find your own path forward to a fresh financial start. I'm Michael Brower, a New Jersey bankruptcy attorney with the law offices of Lee M. Perlman. If you found this video helpful or informative, don't forget to like and subscribe for more information about how bankruptcy works here in New Jersey.